somewhat contorted. So I have a company, and I get elected to the city council, and if the people who employ my company to represent them in a number of activities, including activities that may come before the city council, that's not a conflict of interest?
Not if it's in the future, based on our prior opinion, specifically CEO 11-6, that would not be a conflict.
Do that again for me?
CEO 11-6 is the primary opinion that explains that it would not be a conflict of interest.
And it's not a conflict of interest because the commission said it was a conflict of interest.
I think the reason is because you can't necessarily predict the future, and it's a matter that might come in the future before the city council. There would be a conflict if it's present and the council member personally was engaged with that client.
So what we're saying is there's not a continuing conflict which would prohibit him from holding office, but in the event that somebody who they were actively engaged with presented something to the city council or asked the city council to do something, that at that point it would potentially be a conflict of interest, and he should take the remedies that are available inside the statute.
Correct, and again, it would be him personally, not his company generally.
Is he president of the company?
He is president of,
Single shareholder?
I'm not sure.
I mean, is there any differentiation between him and the company, or are these people just people who work for him?
These individuals, I believe that it would be best to answer that, I believe they are his employees.
When he stays, not right now.
Okay, thank you.
Mr. Anderson, did you have a comment?
Thank you, through the chair. Commissioner Brady, the thrust really here of this opinion is the second part of 112.313.7A, which is kind of grounded in it is grounded in an actual conflict. And the idea behind this opinion, which builds on your precedent, which is opinion 11-6, which is sort of almost a watershed opinion in this area. But the idea is that at the time that your firm works for somebody, that they should not, your firm should not be working for them on a matter that is a matter of your public board. And so if it's early on stuff that is not up to the level of your public board, that may never get to your public board, then the opinion stands for that not being a problem. But it also makes it clear that you better be through with your work on that matter, and you better not be on that matter for a client when and if that matter gets to be a matter of your public board, because then you have the logical intersection of conflict. But of course, the voting conflict law remains as a sort of a backup there, in that, let's say that your firm is not representing the client on a matter that is a matter of your public board, such that you don't have an employment or contractual relationship conflict, but your firm still represents the party on some other matter unrelated to your public board, then there would be a voting conflict there, and you wouldn't be able to vote on matters affecting them, even if those matters were outside of your forum or your government. But this is a pretty sound following on 11-6, which I think was a 19-page opinion that went into a lot of detail at the time about this, but we feel that there is no actual conflict here as the scenario is put forth. Now, if there's a material deviation from the reality that's put forth, which is always the case with every opinion, then there could maybe be a violation. But these folks appear to be acting in good faith, and that's why they're seeking a roadmap so that they won't deviate. But I guess in a nutshell, we think that there's really not any actual conflict here as long as they follow the prescription.
Thank you, Mr. Anderson. Are there further questions? Shelburne?
Have you had an opportunity to review Mr. Shelby's letter from July 11th?
Yes, and we have no objection to substituting the language as he requested.
Thank you.
Any other questions? Mr. Shelby, if you'd like to come forward, you have 5 minutes.
Honorable Chair, members of the Commission on Ethics, thank you for the opportunity. Again, my name is Martin Shelby. I just briefly wish to express gratitude to this board for its work today. Thank you for your guidance relative to my client, for your work that you do providing guidance to local public officials, and particularly to someone like me as a local government attorney. I rely on your opinions. I'm grateful for your work. I'm grateful for your service to the people of Florida on their behalf. And I particularly want to take this opportunity to thank your staff. You have an outstanding staff upon which I have relied on in the 15 years I've been a city council attorney. And I'm very grateful to Ms. Browning and your entire staff, to your executive director for the time and courtesy that they have afforded me, and for the hard work that you have put in and the guidance that you're providing to my client today. It is my privilege to be here, and I thank you for your service.
Mr. Shelby, there's a question about whether you're, I think, he was president.
That's okay.
Okay.
I think,
Yes, please. Or, Brady.
The amended language you suggested, is there a particular reason for the amended language? You just think it's clearer?
Yes, sir. I think it provides more clarity and guidance. It is more of a bright line rule. My concern, and I share this with your staff, is that there are terms within the opinion in that particular clause, in those particular provisos, that I would prefer to be better defined, such as, I don't have the opinion in front of me, but I believe working in matters, if I could just get the opinion if I may.
Yeah, I mean, yeah, I think it's obviously when the matter is before or is a matter of the city council. So in this language, what this really says is that unless his client is doing something with the city council that is a issue that would hypothetically benefit or not benefit them, that he needs to regard that as a conflict. But if it's a more general issue that one of his clients may be involved in and really does not have a direct effect on his client, then it's okay.
The reason that Councilmember Carlson sought out this opinion from the Commission on Ethics is the struggle that we have when it comes to 313(7)A, the prohibited conflict section. And it's sometimes very difficult when advising on these matters to be able to make the distinction, as your executive director did today, between a prohibited conflict under this section and the voting conflict section, 3143, which I call an 8B conflict for my client's convenience, because that's the form that they have to fill out when they declare their conflict. And that's an important distinction, because this opinion really does not address the voting conflict. We acknowledge that that exists. The question is, because frankly, it's very difficult to craft a remedy for a violation of a prohibited conflict, because frankly, you cannot, when presented with it, you cannot just abstain and file an AB voting conflict form, because that in effect is an admission of a violation of section 313(7)A potentially. So that's why Councilmember Carlson proactively has sought the guidance of the Commission on Ethics. And within the language that was originally presented, the definition of work, doing work on a matter, or perhaps when a matter is before or is a matter of, I believe, and I'm grateful to the staff that they have no objection to this, provides greater clarity and a bright line rule. Basically what it's saying, if I can, and I'll be very brief, basically what it's saying is that the council member cannot be engaged for compensation to actually do work to affect the votes of his colleagues in this case. So in regard to that, I believe what that states is a true statement of a prohibited conflict under 313(7)A. And I apologize for going on too long. But, I thank you for the opportunity to provide you this and to work with staff to provide an opinion that gives my client greater guidance.
Thank you.
Are there any other questions, Mr. Shelby? Mr. Farnwell?
I think less question, but just to make sure that I clarify. Council member is your client because you represent the people of the city of Tampa, and you do not represent his firm?
No, I do, I'll start at the end. No, I do not represent his firm. And my position as city council attorney is a charter-created position. I am not the city attorney for the city of Tampa. My clients are the 7 members of the Tampa City Council. I sit with their board, and I provide legal counsel and advice to them individually if requested. Thank
Any
you.
other questions of Mr. Shelby? Thank you, Mr. Shelby.
Madam Chair, and if I may, just for clarification, I believe our executive director stated this, but just to follow with Mr. Shelby, there would be a prohibited conflict under the second part if the council member or his company had an issue. Mr. Shelby just mentioned the council member, but again, under the second part, it's not just him personally, it would be both him and the company for clarification. And the amended language does include that.
Thank you.
I thank you for that. Thank you.
Mr. Burke.
I would make the motion to approve the opinion as amended pursuant to the July 11, 2019 letter by Mr. Shelby.
Is there a second?
Second.
Motion by Mr. Berger, second by Commissioner McManus. Is there any further discussion? All in favor, signify by saying aye.
Aye.
Any opposed, like sign? Motion passes unanimously. Thank you,
One
Mr.
extension.